Hello and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Ed White, and today I'll be joined by my partner, Janet Cho, one of our team members in our intellectual property practice group here at Williams Mullen, and we're going to discuss Brexit and its effect on international trademark portfolios. Janet, how are you doing today?
I'm doing well, Ed. How are you?
Good. I'm glad you could join me for this. I think it's actually a very timely topic. Before we get going, for our listeners, I will just touch briefly on Brexit and also describe for them what an EU trademark registration is, since we'll be discussing that. Does that work for you?
Yeah, I think that's a great idea.
Okay, excellent. Well, as many of our listeners certainly will already know, Brexit is essentially a made-up term. It's made up of the term British and exit, and it essentially identifies the UK's withdrawal from the European Union. This has really been something that's been ongoing. I'm sure people have heard a lot about it. The actual vote by the UK citizens to withdraw from the EU happened all the way back in June of 2016. It was a relatively close vote. 52% of their citizens voted to withdraw from the EU. 48% voted to remain. And probably because of the closeness of that vote, there were a lot of machinations and iterations that were handled through Parliament as to when and how they would implement Brexit. Well, this may surprise some of our listeners, but Brexit actually did occur. And it occurred early this year on January 31st, 2020. And it occurred with the implementation of a withdrawal agreement. Now, the withdrawal agreement itself, the main thing is that it puts in place a transition period of 11 months that will end this December 31st. And during this transition month, the UK will be working on ongoing issues that it must conclude with the EU, including things like citizens' rights, how they will do border checks along the Irish border, the UK's financial settlement with the EU, and certainly and importantly, part of this is how intellectual property assets such as EU trademark registrations will be handled vis-a-vis the UK once the UK is no longer a member of the European Union. So let me just touch now quickly on what an EU trademark registration is for those who are unfamiliar with that. An EU trademark, or EUTM as it's sometimes known as, is basically an application that one can file in the European Union Intellectual Property Office. If the application matures to registration, the EU trademark registration will grant the applicant exclusive rights in all current and future member states of the EU through a single registration. The application's filed online. If it registers, the registration is valid for 10 years, and it can be renewed indefinitely for 10-year periods. So it's a very efficient way of obtaining an enforcement tool in the EU for all of the EU member states. So with that sort of introduction to Brexit and EU trademark registrations, Janet, let me turn this over to you and ask you, if a client has in their international portfolio currently an EU trademark registration, what should they be thinking of and what should they be doing in light of Brexit in the phase out that's ending on December 31st?
Yes, thank you, Ed. And for ease of reference, I know I call EU trademark registrations EUTMs. And so I think in the interest of not repeating four big words, I will just call them EUTMs. But
excellent idea.
Certainly the first step is, I think, take a look at your portfolio, see what you have registered, see what you have pending, and take a look at what's actually being used and what's being used where, because the common refrain I'll have during this podcast is Brexit essentially means, which I think we all know, but just to remember that after December 31st of 2020, the United Kingdom and the EU will become separate jurisdictions. And so what you may have previously relied on in one jurisdiction to kind of cover you in another is not something that you can rely on anymore. So I think perceptually and principle, you need to think about those two jurisdictions separately. And I think certainly if you have registration, so if you currently own an EUTM and you have a registration in the EU, you're probably perhaps in the best circumstance, because there's very little you need to do, because on January 1st of 2021, the United Kingdom Trademark Office is going to take your all EUTMs and essentially convert them or file for you grant you a new registration or a counterpart registration in the UK. So basically what that means is now your EUTM will result in a UK trademark registration. So if you have 2 EUTMs, you'll have now 2 UK trademark registrations as well. So you'll essentially expand your portfolio exponentially depending on how many EUTMs you have. So I think as a registrant, there's nothing you need to do. There's no fees you have to pay. You don't have to instruct your attorney or the UK Trademark Office to do anything. This is just automatically done, and your priority date will be maintained as well. So it's a good thing in the sense of growing your portfolio. Now, the practice point to that is you need to remember, going toward the separate jurisdiction issue, is that now your UK trademark registration should be noted as such for your records. So it's going to have a separate registration number, a separate identity. So you should note that in your records, and then you'll also have to maintain that UK registration separately as well. So even though I suppose at the end of this year there's very little you have to do, going forward you're going to have some additional administrative concerns or use concerns to think about to maintain any new UK registrations that might issue.
No, that's good, Janet. And it's a very good practice point there. It's nice that they've made it as seamless as they have with regard to the comparable UK registration, but you're absolutely right. People will really need to be on top of how their portfolios have grown in those maintenance dates in the UK as well as the EU. So that's excellent. Thank you. What if a client, they don't have the registration yet, but they have an EU application that they filed, but it is still in the process of being examined and prosecuted beyond December 31st? What happens to that EUTM application?
Yeah, so that's a very good question. And unlike the registrant, the EUTM registrant, if you want to maintain that application after December 31st, 2020, you as the applicant do have some work to do. So basically, if you have an application pending after December 31st, 2020, an EU application pending, you will have until September 30th of 2021 to apply to transition your EU application to a UK application. So you definitely have some time to plan, to marshal your resources. However, again, the practice point on this transition application is that when you do this, you have to pay a UK application fee, and then that UK application is examined just like any other UK application. So going back to the registration scenario, whereas with EUTMs, you're automatically granted a UK registration for applications, it's not an automatic grant. You're going to have to face the UK application procedure, UK examination procedure, and perhaps any other office actions or what have you that will come up. So I just want to emphasize that it's not an automatic grant, and there are some fees that need to be paid. And then if there are any fees that are applicable at the time of registration, should you be granted registration, those will have to be paid separately as well. So the UK, the potential UK applicant certainly has some work to do, unlike the EUTM registrant after January 1st of 2021.
Yeah, that's a really important distinction, isn't it? I think that applicants will obviously hope and pray that maybe they'll have a registration issued before December 31st, but in the off chance that it's not, they really need to be on top of that. Well, now let me ask you this, Janet. We've talked about EUTM registrations. We've talked about EUTM applications. Going forward into the future, what should international portfolio owners be thinking of with regard to new applications? What should they be thinking about with regard to maintenance of existing registrations as far as use both in the UK and the EU?
Yeah, that's a good question. And one thing I will say, this applies to your question, and it also harkens back to our discussion of existing EU registrations. One thing to note is that if you currently own an EU TM that has been the subject, say, of an opposition proceeding or a cancellation proceeding, and your goods and services have somehow been modified. So let's say there's a portion of your goods or services that were deleted pursuant to a cancellation or opposition proceeding, then your counterpart UK registration that you're granted as part of this Brexit transition will reflect that changed registration. So in other words, this is not the opportunity where when you get that UK registration, it's going to harken back to sort of the original filing of goods and services. So I want to make that clear, that it's not a potentially a do-over if you happen to have some of your goods and services restricted. So that's definitely one thing to think about for the future. So however your EUTM looked on December 31st is how your UK registration will look on January 1st. So I just mentioned that as a use point and as a practice point. So you're not going to get an enlarged scope of goods and services with this transition. The other thing to think about with use is both the United Kingdom and the EU have use requirements. So if you have not used your mark for 5 consecutive years, it could be susceptible to an invalidity proceeding for non-use. And how Brexit makes this a pretty compelling point is that if your 5-year period accrued before the Brexit transition, then, for example, your use in an EU country that was not the UK can apply to your subsequent UK registration. But if your 5-year period is somehow broken up by Brexit, then only your use in the EU prior to Brexit can be applied to prove use of your subsequent UK registration. So in other words, this is kind of going to the point of the EU and the UK being separate jurisdictions, that once Brexit happens, so on January 1st, 2021, only activity in the EU before January 1st can really count toward your subsequent UK registration. Going forward, you're going to actually have to use your mark in the UK to maintain your UK registration if you're actually in a situation where you might have some non-use. So I think ultimately you want to be strategic as you think about what you may be applying for and what you may be granted. It can be really a very positive thing to have your portfolio grow, but if there are some concerns or some questions about how the use is actually executed and during what time period, that's something to think about, because now you can't really rely on, sort of the interplay between the EU and the UK as perhaps maybe a party would have in the past before the Brexit before December 31st, 2020.
Yeah, no, that's a very good point. And it really is something that our clients and the listeners on the podcast need to think about, because oftentimes, I think, given the U.S. law where use is required before registration, that is sometimes lost when it comes to, or that concept is lost on people when it comes to European portfolios, where oftentimes it's first to register and use only comes into play when it comes time for maintenance and to ward off a third-party opposition or cancellation proceeding. So it's important to think about that use that you'll need to have in the UK and the EU. Hey, Janet, one more thing I wanted to touch on, which I think might be helpful with regard to this podcast, is going forward how people will clear marks in the EU. I will say that what I have found is that many UK firms will oftentimes have offices within the EU and EU countries. And therefore, if we were to reach out to a UK firm that has an EU office, I think that should enable us to obtain an EU clearance assessment, meaning is the mark available for use and registration within the EU and the UK. That should be fairly seamless. But with regard to UK firms that might be just UK centric, I think clients will now need to think about moving to other firms who can help with that EU assessment piece for clearance in other EU member countries. And I just wanted to mention that because I think we have a fairly strong network of firms throughout the European Union that we can rely on for those clearance pieces. Do you have any additional thoughts on that piece?
Well, I agree with you. I think that, again, toward the notion that the EU and the UK are now separate jurisdictions, if you were a party that was looking to clear mark in, say, Canada and Mexico, you would probably engage counsel in those particular jurisdictions to search the register or give you a commercial analysis of those particular regions. we need to think about the EU and the UK in the same way. So if you have a UK only firm, I suppose, without capability outside of the United Kingdom, then the best, I think, my recommendation, consistent with what you just said, is to also engage a firm or work with a firm that is based in the EU that can give you a sense or provide a proper analysis of the EU register and the EU commercial marketplace. So I agree with you to continue to treat the two jurisdictions as separate.
Yeah, no, thank you. I felt like it was probably helpful to maybe just touch on that piece, even though it's somewhat hypothetical. Nevertheless, I'm sure our clients will have needs that will come up in the future, as well as potentially the podcast listeners who will have needs in the future with regard to clearance in the EU versus the UK. Well, that will wrap up our discussion about Brexit and its effect on international trademark portfolios. I'd like to thank Janet for joining the Trending Now IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as our past episodes of this podcast and our legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. And until next time, this is Janet Cho and Ed White. Thank you.
Thank you.